and I represent the appellant, April Elizabeth Tauscher. I'm asking the court to reserve 4 minutes for appeal. As this court said as recently as July of this year in the Deming versus Deming decision, Rule 1.540 does not allow a trial court to serve as its own appellate court. And fundamentally, that is what the trial court in this matter did.
Well, let me ask you about Deming. Thank
Yes.
you for bringing Deming up. Deming tells us very recently that the court reserves jurisdiction to enforce orders judgments, correct?
No question.
It also tells us that it has the ability to postpone calculations dealing with military retirements, correct?
That's an option available to a trial court, but that is not an option that the trial court in this case availed itself of. In this particular case, the trial court entered an order awarding 30% of the appellee's retirement. As the trial court did correctly find in the trial court order here, as written, that applies to 30% of the whole. So in Deming, while the trial court there specifically reserved jurisdiction and said, we're going to figure out how we're going to, both the formula, its application, and the numbers prospectively once the retirement happens, that's an option available to it. In Deming, the court availed itself of that option. In this case, the trial court did not avail itself of that option and instead simply entered an order awarding a blanket 30%.
Well, did not the court avail itself of that option in the enforcement action, the recent enforcement action, which enforcement, as I read the motion, was asked for in the alternative? Wasn't this simply an enforcement action enforcing the tenor of that, I guess it was a second supplemental judgment, final judgment, that the military retirement would be those dollars that accrued during the marriage?
And at the end of the day, that's basically the fundamental question is, can a trial court enforce its intent from a previous order into incorrect secondary order? Because the trial court here found that the order, the quadro entered as written clearly applies to the full 30%. So to rephrase the question, can the trial court's expression of intent in a previous order be enforced by even if it's later contradicting a second order? And the answer to that is no. And there's two cases that I cite to for that proposition.
Explain that to me, counsel. Are you saying the predecessor judgment that talked about accrual during the marriage could not be superimposed on the later judgment? Is that what you're saying? That's
correct. And there's case law to that effect. I point the court to the Nahum decision by the 3rd District, where that's exactly what happened. There the court held that we therefore hold that the trial court was without jurisdiction to amend the final judgment by changing the provisions thereof, even though the court may feel that the amended final judgment more fully expresses its intentions than is set forth in the prior final judgment.
Well, let's just think this or try to reason it through logically. We know at the time of any of the final judgments, the law was resolute. The cases, the statutes.
We concede the point, Your Honor.
That there was no entitlement to post-marriage accrual of those retirement benefits. Would you not agree with that?
I agree that had the appellee timely appealed within the rules, he would have been entitled to relief, but he didn't do so in this case.
But what about that second supplemental final judgment is something that's contrary to what I just described to you, meaning contrary to law, contrary to the statutes, contrary to the jurisprudence of the state? What about that runs afoul of what we just talked about?
The order which says the underlined accrued during the marriage, there's nothing in that per se that is wrong or illegal, and we're not alleging as such. The problem comes in is where we get into the judgment that comes in after that, which blanketly awards the full 30%. To me, the best analogy is, I brought this out in the in response in the reply brief, is the Wilder decision, which is a very, very, very similar situation. It's a 1971 case out of the 4th District. And in Wilder, there was an oral pronouncement where the court said, we're going to make the life insurance payable this way. He ruled that way. There's a transcript. There was later an order entered which was contradictory to what was done by the oral pronouncement. And more than a year later, they moved to fix it, to have the judgment that was entered correspond to what the oral ruling was. And in that case, the 4th District held that you can't do that because even though that was the court's intent, that was the court's order, we're now more than a year later. And even though the order of the court was clear and its intent was easy to resolve, because we're dealing with the time constraints of 1.540, there's simply not a mechanism within the jurisprudential whereby jurisdiction can be conferred to do that. Because at the end of the day, this is not an equity question, it's a jurisdictional one.
Well, I'm going to ask you about the equity in a minute.
Yes,
Equity is under 1540B5. But before we get there, I didn't see in the briefing, but there's a case out of the 2nd DCA. It's an Alterburned opinion that appears to me to be on all fours with what we're dealing with here. And I know we didn't bring that to your attention before this morning, but it dealt with a percentage and nothing more than a percentage, and a later attempt to modify.
Is that the Ingram decision, Judge?
Yes, sir.
I did brief the Ingram decision. It does appear in the...
So it does?
It does appear in the appellant's brief.
Why is that not squarely on all fours with this case?
Because...
I mean, we have a... Let me finish. Thank you. There's a 50% number. Here we have a 30% number. They are different from here. We have a petition for modification and not a petition or a motion for enforcement. And the court said that was a good enough thing to allow the modification, so-called enforcement of that earlier judgment. Why is that not squarely on all fours here?
Because the same facts that exist in Ingram exist in Janovic, Self, and the other cases cited by the appellee, to wit this. All of those cases, including Ingram, include a marital settlement agreement whereby the parties entered into a marital settlement agreement and then had the court ratify that later agreement. And so when interpreting what's meant by a marital settlement agreement via enforcement or what have you, there's ample case law when it comes to, well, therefore we have the law of contracts to help us interpret what was meant by entering into the marital settlement agreement. There is no such analog for raw court orders entered without an agreement.
I don't remember that analysis in Ingram, though, saying just what you said, meaning we're going to look at this from a contractual standpoint and we're going to evaluate the party's intent from a contractual standpoint. As I read Ingram, it talks about enforcement. Alterburn talks about, in essence, the court's right to enforce its judgments. Even in Ingram, because it's present in all the cases where they say we're enforcing the agreement as the parties understood it. That wasn't dispositive of the case because that was the law that applied in those cases, and I don't quarrel with that, so it wouldn't have been part of the analysis. But even there, they state we're looking at the intent of the parties via this contract that they entered into, and therefore we're enforcing the contract through what we're doing here. There is no such analog for a raw court order which is entered, which is what we have here, which is what was present in Wilder, which is why, again, the court doesn't have the authority nor has the jurisdiction to amend what we concede, which would otherwise have been a faulty distribution if timely appealed. Well, let me ask you about B5,
Yes,
1540B5. And I think that language is it is no longer equitable that the judgment would have prospective application. You've conceded, and thank you for conceding, that this second supplemental final judgment was contrary to the law, the statutory scheme, now the federal law. Why would that not be inequitable? Would it not be inequitable for the circuit court to enforce something that could not have been ordered to start with? I don't know. That seems to me to be the essence of inequitable. But
well, because inequity in the common parlance, as we talk about it, for what's equitable and fair is not the term. Is not equitable as it applies to the rule. And I'll also point out that that's 1.540, and this court has held in the Pruitt versus Brock decision, because that's 1.540B5, that 1.540 and relief from judgment cannot be a substitute for the taking of a timely appeal or seeking appellate review. And the one primary fact which I think decides this case, which is conceded by the appellees in this particular case, is that at the time the erroneous quadro was entered, the appellee had all of the information necessary to then file an appeal. It was erroneous on its face. The time limitations were clearly there. Counsel for the appellee at that point to the time could have filed a motion for rehearing, could have brought the mistake to the trial court or the appellate court's attention. It didn't do so. I refer the court also then to the Department of Revenue XRL versus Stevens, which I do cite in the answer brief, where it talks about this B5. And it said, what would be the point of a 1-year limit on fraud if a mere inequity can be the basis for relief for a judgment of any time? Indeed, Boswell never offered any evidence that the mother did commit a fraud. How could equity offer greater protection to someone who merely failed to exercise his rights than to the victim of a fraud?
Well,
that's fundamentally this case.
Well, I see you're in your rebuttal time.
I'm in my rebuttal time. Thank you, Your Honor.
I'll save it for rebuttal.
Yes, sir.
May it please the court. My name is Jonathan Benson. I represent the appellant James Tauscher in this case. And this court should uphold the lower court's decision, which would be the order enforcing the supplemental final judgment, because the trial court had the jurisdiction to enforce the award of military retirement. The trial court applied the right standard through its enforcement jurisdiction.
Well, why don't we start where counsel ended? Why was there not an appeal of that second supplemental final judgment?
That second supplemental judgment could be interpreted in the correct way. If we take a look at the supplemental authority, albeit untimely filed, but the Uniformed Services Former Spouses Protection Act defines military retirement at the time of dissolution. So if we take the definition from the federal statute being applied, that quadro, if applied correctly by DFAS, the Military Retirement Division, should have been 30% at the time of dissolution.
Was that federal statute in effect at the time that second supplemental final judgment was entered?
It's my understanding. It's referenced in the supplemental final.
Well, the new language, I think the language may have changed in 2017. Now, if it's the same language back in 2006, I understand your point. But as I read what you filed with us, it was perhaps revised language. But so you're assuming that language, as you filed the statute with us, was the same language that would have applied in 2006?
That was an assumption on my part, but to couple that, that act would apply state law when it comes to dissolution and equitable distribution. The retirement benefits accruing after the marriage were not subject to equitable distribution, so they shouldn't be part of that 30%.
Well, and it sounds like from all sides, that's a given, that everyone understands what the law is. Boyette and many other cases have said, as well as the statute would not allow it. I think their point is, you have something that was different than what it should have been, contrary to the law. By virtue of that, there should have been an appeal taken, and with an appeal not having been taken, that issue has now been waived because there's no jurisdiction to rectify that. So what would you say?
The appeal would not be the proper route. The proper route would be found in the Self case, Janovic case, where the court clearly has the jurisdiction to amend a quadro to enforce the actual award, the award being the military retirement accrued during the marriage pursuant to the first supplemental final judgment.
What about Ingram? Does Ingram, is that our facts here? Is that very akin to what we're dealing with in this case?
Yes, sir, I believe so, and I believe that the argument that those cases involved an agreement, whereas our case didn't, that's a null argument. Number one, an agreement that is incorporated into the final judgment, those terms become part of the final judgment, and that's what's being enforced. Also, we did have an agreement in this case that was referenced in the final judgment. There was some sort of agreement regarding equitable distribution. The terms, while they're in dispute and the court didn't make specific findings as to the terms of that agreement, the equitable distribution provisions of the final judgment reference an agreement in this case.
Well, in the agreement, did that involve the military retirement?
It's my client's position that it did. Again, the court did not make specific findings as to what were the terms of that agreement.
In your client's position, explain that to me.
My client's position was that the former wife could go pick up all of the items of marital property as long as she waived her interest in the military retirement.
Waived what interest?
Any interest that she may have. Just, she would not have any entitlement to any military retirement. She could have all of the physical property.
All right, please proceed. And before you move on, explain to me why you believe that 1.540B5 may apply to this circumstance.
Yes. Again, because the quadro, when entered, could be given effect at that time. It's inequitable to have it have effect at any time afterwards, prospective effect. As a static order, at the time of the final judgment, 30% stands. Any time afterwards would be inequitable.
What about the retort to that? This jurisprudence from our court, cases from our court say that it can't be used as a second appeal. I think that was part of the argument. And then second, we only give a year for fraud, so how can you give 12 years, 11 years for something that's purportedly inequitable?
While there may be some argument that the quadro was clearly inaccurate on its face, it wasn't. It was inaccurate as applied by DFAS. My client moved to change the quadro to the correct terms, to change the wording of it. It didn't change the substance of the award, but he did so before it was ever even applied, before he retired, before it was applied by DFAS. It was when he was approaching retirement and found out that it would be applied to everything he had accrued after the marriage that he went and asked the court to change the terms of the quadro.
And that was my question, is that he hadn't retired at the time this issue arose. He was, like you said, you just said he was about to retire.
Yes, it was in approaching retirement that he found out that the former wife was applying for 30% of the entire retirement.
Yeah, beyond what was accrued during the marriage.
Yes, sir. And no further questions at this time? So my argument would continue that the specific jurisdiction to amend the quadro and to the court had the specific jurisdiction pursuant to Self, Janovic, and Ingram. And then what we have to look at is what did the court do in the appealed order? Was it modification versus enforcement? Our argument is that it was enforcement.
Did I miss something? But in the second supplemental order, there was an express reservation of jurisdiction.
Yes, to comply with the act, with the statute that I
Okay.
cited, and am unaware of the actual time of the amendment. But that statute at that time, regardless of the wording and the definition that I have cited, that statute would have deferred to the state's substantive law regarding equitable distribution, which again would show that anything accruing after the marriage was not subject to equitable distribution, and therefore the court's reservation of jurisdiction in the quadro would allow the court to go back and change the quadro to comport with an award of military retirement accrued during the marriage.
So it would be your client's position that the provision Judge Makar just referenced, which is paragraph 8 of the second supplemental final judgment dissolving marriage and qualified military order, saying this court will retain jurisdiction for the purpose of making any amendments to the final judgment, etc., would have retained jurisdiction to do what the court did in this case?
That is part of our position, yes, Your Honor.
Because the latter part of that, paragraph 8, says to enable these orders to qualify under the act. So that seems to limit the scope of the application to some extent.
It could be interpreted that way, but again, it would be our position that to qualify under the act, it would have to be in conformance with state law. Because again, the act does defer to state law when it comes to the community property states and what property is subject to equitable distribution. So in looking again at the original award, it would be our position that the quadro did not embody the original award. The original award was determined before that. And the record is a little hazy because it wasn't specifically mentioned, but the first supplemental final judgment, you can see that there are filings immediately right after it, and it's our position that those were attachments to the first supplemental final judgment, that being husband's exhibit number 8 from the original trial, which shows the actual calculations, 30%. It shows the available military retirement at the time to be $1,771. That's not in dispute. 30% of that would be $531.30. Therefore, that was the actual award, rather than the 30% found in the quadro. There is a monetary award that could be attributed to that, and that's why, again, the terms of the quadro, while some of the actual language and the words were changed, the effect was not changed. The problem in this case was how DFAS actually interpreted the order at the time of the husband's eventual retirement.
You also made the argument that, as best I understand it, that as read by the appellant, this final judgment potentially could have been void, and therefore there would be entitlement under 1540 to seek relief under the pertinent provisions. But as I understand void judgments, there would have to be no subject matter jurisdiction and no personal jurisdiction. You're not contending there was no subject matter jurisdiction and no personal jurisdiction over the parties in this case.
The jurisdictional side of that argument has to do with the fact that anything accruing after the marriage, the court didn't have the ability to actually divide military retirements accruing afterwards. But the real crux of that argument is the due process argument. The former husband was not on notice that his retirement accruing after the marriage would be subject to equitable distribution.
Wouldn't that, assuming all that to be true, wouldn't that make it voidable and not void?
It would be our position that it would be void. He didn't subject himself to the jurisdiction to let that happen, nor did he know that that's how it would be applied. Again, 30% at the time it was entered, okay, that's correct. When DFAS wrongly applied it to all the military retirement accruing after the marriage, that's when it was found out. So the former husband was not aware that it would be wrongly applied during the appeals period and didn't have the ability to apply it because, again, he didn't know. There's other contentions in the record not put in the brief, but I will put before this court that the former husband was in continued military service, and it is positioned that there was a little discord between him and his counsel in the original trial, as well as his continued service. There is a letter in the record that does show that he was about to be shipped off to, again, another tour of duty. And so it's his argument that continued military service was part of why he didn't follow up on these procedures. He didn't know about the quadro until the actual substance. He didn't get a copy of the quadro until 9 years after it was entered. So now going back to a couple, again, we've talked about this argument, but the specific reservation of jurisdiction in the first supplemental final judgment, in the final judgment itself, the case law is very clear that a specific reservation of jurisdiction for enforcement purposes is unnecessary. The court has inherent enforcement jurisdiction. A reservation is a null argument, which was another distinguishing factor that the appellant cited as to why the Self case and Janovic should not be applied in this matter. So between the specific jurisdiction argument and the fact that the appellant claims that those cases involved an agreement, that again is a null argument because the agreement as incorporated into the final judgment should be interpreted as the terms of the final judgment. There's no those cases are not distinguishable. Those cases should squarely be applied. Ingram, cited by the appellant, as well as Self and Janovic, that they're on all fours with this case. The court clearly, without worrying about the equitable jurisdiction, that only happens if the court cannot enforce its prior order. So really we need to look at the court's ability to amend a quadro to comply with the actual award, which was military retirement accruing during the marriage. That's what state law provides for. That's what was done in this case. It's very, very specific. And then, we cannot ignore the inconsistencies. Again, the court has mentioned, so should we ignore, or was there something wrong with the first supplemental judgment? No. If the quadro is applied as argued, then it's inconsistent with the first supplemental final judgment. To let it have legal effect, to allow it to stand, to allow it to comply with Florida law and federal law, it should be applied at the time of dissolution. That's what the law would have provided for. If we can just interpret it that way, tell DFAS how to interpret it, it has the exact effect that it should, 30% at the time of dissolution. Thank you. Any further questions?
Thank you, counsel.
Further, thank you.
Thank you, Your Honors. And if I could just start off with pointing the court to Judge Makar's decision in Powell versus State. That's 120 Southern 3rd, 577, which admonished an appellee for raising new arguments at oral argument. And the application and interpretation of the federal Quadro statute was never raised below. It's not in the briefs. It was filed 2 days ago. About their position. So I'd ask the court to disregard the new arguments raised today. But to start off with the last point first is essentially what counsel's argument here is that the second judgment, the final Quadro, which called the final judgment, is inconsistent with the previous order. We agree that's the case. The problem with that is a mere inconsistency from Order 1 to Order 2. There's no case law which says that because it's inconsistent, the jurisdictional rules don't apply. And fundamentally, that's the argument here, is because there's an inconsistency between the court's first order and the second order, the court can choose at any point in time and in perpetuity, I'm going to enforce Order 1 by modifying and amending Order 2. And that is the jurisdictional jurisprudence which is being created in this case. That doesn't exist elsewhere. Now,
let me ask you this, counsel. You don't dispute that, or do you, that your client's entitled to only 30% of the retirement accrued during the marriage?
if that were the issue on appeal, no, I would not.
But you don't dispute that's what she's entitled to?
If that were the issue on appeal, no. What we do dispute is the jurisdiction of the trial court to change order number 2 because
Okay,
it's
so
inconsistent
let's
with
flip it. So now you're representing the other side. Your client has seen that there's a problem here and needs to be corrected. What do you do to correct it?
Well, the first thing I would do, and in fact, I'm going to refer to what Mr. Benz just said. He said, my lawyer didn't send it to me. I would admonish my lawyer for making sure that the order was correct in the first place. That's why we have lawyers. I mean, look at the order here. The order here is copied to counsel for the appellant, or the appellee in this particular case. They got a copy. It's erroneous on its face. It's erroneous in the same manner that in the Howerton case, the Howerton, which is what establishes the law that we're talking about here.
Well, let's say it's ambiguous, because it looks like here the previous order talked about duration of the marriage. The next order didn't have that phrase.
But respectfully, it's not. And both the trial court and the defense department found it wasn't ambiguous and applied it as written. And the trial court here says and in fact, I believe conceded in the way it's written in the petition in this particular case filed by the appellee, as written, it applies to the 30% of the whole. Now, the appellee in this particular case knew at the time of the rendition of the disputed quadro that it applies to 30%, it applies blanketly to 30%. The appellee knew he was continuing in military service, and the appellee knew he was subject, therefore, to the appropriate rules to bring this court to bring that issue to appropriate resolution via motion for new hearing, within 1.540, new appeal, none of which was alleged. So essentially, and here's really the issue. This issue could have been addressed by the appellee within the rules. It could have been done. And he's asking the court as a fail-safe to enforce its way out of jurisdiction to essentially give him relief outside the rules. That's jurisprudence that is contradictory to this court's case law. And that's why I pointed the court in my conclusion to the Hall versus American Distribution Corp., which says that basically, although there's a certain foundational belief that you can do so, the finality of judgments is at stake. Thank you.
Counsel, we appreciate both of your arguments. We will be in recess.
All rise.